Position number 524A04289, Abraham Gray versus John McManus.
I believe that's my motion, Your Honor. I'm Sarah Galloway.
I have a motion to dismiss the amended complaint.
Correct.
Okay, go ahead.
My name is Sarah Galloway. I represent the defendants in this case, John McManus and McManus and Associates. They filed a complaint alleging fraud, unjust enrichment, breach of fiduciary duty, and conversion, as well as legal malpractice arising out of the defendant's actions as the escrow agent and closing attorney for a loan between plaintiffs and an entity called TFRS. They're essentially alleging that they deposited funds into the defendant's escrow account pursuant to a loan agreement, and he then transferred them to a New York-based attorney who then rerouted them to a foreign entity in an overseas bank account. Importantly, the defendants are not parties to the loan agreement, which is attached to the plaintiff's complaint. I know you're familiar with the procedural posture of this case. We filed a motion to dismiss. The plaintiffs amended their complaint, which the new complaint was identical to the old one, but for the redaction of the legal malpractice claim. And you entered an order denying the motion to dismiss the original complaint, finding that our motion with regard to the expert affidavit was moot because of their dropping of that case, and also denied it on the basis that there were indispensable parties that needed to be joined. So we have now filed the motion that's before us today, which is the motion to dismiss the amended complaint. The plaintiff's failure to file an expert affidavit is fatal to their case. No matter how the plaintiffs attempt to characterize this action, it is a suit for legal malpractice. All of their claims concern McManus's legal advice and his actions when acting as an escrow agent. I refer the court to two cases that are cited in our brief. One is Merritt's versus North Georgia Veterinary Referral Practice. That's at 366 Georgia App 756, 2023 case. That has almost the same procedural posture as ours, where the plaintiffs originally sued for multiple claims, including professional malpractice. The defendants moved to dismiss. They filed an amended complaint dropping the professional negligence claims, and the defendants filed a second motion to dismiss, and the trial court granted it, and the Court of Appeals affirmed, finding that, explaining that the plaintiff's characterization of the claims does not control. Instead, it is what the nature of their claims are. In our case, notwithstanding plaintiff's characterization, the allegations call into question the defendant's professional judgment and competence as an attorney. They allege in the amended complaint that the defendant had a duty to act, or that the individual defendant had a duty to act as a reasonable attorney would act in a similar circumstance, and failed to do so. I also refer the court to Fortson versus Freeman, 313 Georgia App 326, which is a 2011 case. Here, the plaintiff's claims sound in professional negligence in mishandling and or misrouting these escrow funds. They allege that McManus failed to act as a reasonable attorney would in the same or similar circumstances, and those are simply malpractice claims. The second basis for our motion is that the complaint should also be dismissed because they failed to join indispensable parties. This case is factually complex. I'm kind of pinch hitting for someone today, and it took me a bit of time to wrap my brain around it. I encourage the court, or request that the court take a look at our counterclaim that is in both the amended complaint and in the original complaint. It kind of explains these facts a little bit better. We're moving under OCGA 91119. The two indispensable parties are TFRS and Alpina. TFRS, as you will recall, is the borrower in the loan agreement that is attached to the complaint, and the entity that failed to repay the loan to the plaintiffs. Alpina entered into a loan agreement with TFRS. It's a $10 million loan agreement under which TFRS was to deposit $2 million into an escrow account, and McManus was the escrow agent and the closing attorney for that. Unbeknownst to Alpina or to the defendants, to get that $2 million, TFRS had to borrow money from the plaintiffs in this case. Plaintiff Gray, the individual plaintiff, represented to McManus that he was a partner involved in TFRS. So McManus assumed he was acting on behalf of TFRS when he sent the emails regarding the escrow fund. McManus then followed Alpina's instructions on disbursement of the escrow funds, wiring them to an attorney with whom he had had prior involvement in dealings, and that attorney then transferred the funds to another entity. After Alpina learned of the misrepresentations on behalf of TFRS, regarding the source of the escrow funds, Alpino declined to consummate the transaction or to refund the escrow funds to TFRS, who in turn then failed to repay the plaintiffs. Thereafter, this is important, Alpina, TFRS, and plaintiff GPP, which is the corporate defendant, plaintiff, entered into a settlement agreement for Alpina to pay the settlement to GPP. Now that has not, unfortunately, the funds have not been transferred for a variety of reasons that Alpina alleges. But the bottom line is plaintiffs know that neither defendant owes them money, neither defendant kept the escrow funds, and they know that the defendants were unaware of this ancillary loan agreement. The only one they were aware of is the agreement between Alpina and TFRS. They were unfamiliar with the plaintiffs. Nevertheless, they filed this lawsuit against the defendants only, but it cannot proceed without joining TFRS and Alpina as indispensable parties. Alpina has the money. Complete relief cannot be afforded to the plaintiff without it or without TFRS, who made the misrepresentations to Alpina, causing Alpina to keep the money, and they refused to pay to pay the loan back. So without them, the defendants are at a substantial risk of incurring inconsistent obligations that are inconsistent with the settlement agreement. And for these reasons, we ask the court to dismiss plaintiff's amended complaint. Thank you.
Thank you. Let me hear from the plaintiffs.
Your Honor, this is really not an inordinately complicated situation. The money was wired to defendant and with the specific instructions that the money would not be transferred anywhere. Despite those instructions, defendant transferred that money. So it's very simple. Counsel brings in all these other arguments and facts that are not present in their motion to dismiss. And with the relationship between TFRS and Alpina, and these are new arguments that we haven't had an opportunity to address. So I would ask the court to not even consider those and strike those. I think it's if Your Honor looks at Exhibit C to the amended complaint, it's quite clear. Mr. McManus says, defendant, I have received instructions from my client, Alpina. His client was Alpina, not the plaintiff. The plaintiff has no attorney-client relationship with this person. He was an escrow agent that was supposed to hold the money, period. And this is not a claim for legal malpractice. That was dropped. There was a remnant of that competence as an attorney, but that was more descriptive, and that was only for one count in the complaint, and not for the rest of the complaint. Basically, he was given money. He wasn't supposed to transfer it. He promised he wouldn't transfer it. It was fraud on his part, and he took that money and he transferred it despite specific instructions not to do so. That has nothing to do with him being an attorney. It has nothing to do with his representation. And it doesn't even come close to the cases that counsel cited. Even in the case that we rely upon, the state of Shannon versus Ahmed, 304 Georgia App 380, that dealt with medical treatment where there were fraudulent representations made, and the court ruled that even though it was even in the course of medical treatment, because there was fraud, and they dropped the medical negligence counts, that the case could proceed. With respect to the necessary parties, this court has already ruled on those necessary parties being part of this lawsuit, and we asked the court to just apply the reasoning from the prior ruling, and basically there's no need for these parties. This person transferred money that wasn't his to some third party. Okay, that was his client. Okay, not us. And now my client is out $2 million as a result. There's nothing to do with representation. Our client did not rely on any um, legal reasoning or legal advice, or did not seek legal reasoning or legal advice from this person. He was only holding the money contingent upon some other transaction with the promise that he would not transfer the money. So, and we in our brief, we kind of addressed those points to the effect that I believe it was count where we talk about where there was some remnant of him as a reasonable attorney that was more descriptive than it was related to our allegations that he converted the money for his own uses or for the uses of others. So it wasn't, and to the extent that Your Honor perceives that to sound in attorney malpractice, we certainly, that the language is not necessary to our complaint or our allegations. So for that reason, we ask the court to do what it did last time and basically deny the motion to dismiss because this is simply theft and nothing else.
Your Honor,
60 seconds.
Okay. Yes. As the plaintiff's attorney explained, the defendants were not parties to the loan agreement, to this ancillary loan agreement. So they're alleging that he failed to follow instructions from the parties in a completely separate loan agreement that he was unaware of. They alleged legal malpractice claims originally, and they continued to do so in paragraph, I believe it's paragraph 48 in the amended complaint. And although the plaintiff is characterizing it as descriptive, the bottom line is they're alleging that he did so in his capacity as an attorney and an escrow agent. With regard to the argument about indispensable parties, I'm sorry, actually, with regard to the first argument that we have, plaintiffs don't allege that the defendants kept the money in the complaint. They allege that that McManus, and through his law firm, transferred it to another party. They want him to return money that he just doesn't have. He wasn't a party to the underlying loan agreement, and he should. Their complaint doesn't allege a proper claim against him as a matter of law. Thank you.
Briefly, Your Honor, this was money that he was provided, and he was not to transfer it to other parties. Whatever deal counsel just discussed for the first time today and not in the brief has nothing to do with the fact that he was an escrow agent. He was to hold the money and not transfer it. He transferred the money, whether he has it or not, or whatever happened to that money is irrelevant to the fact that he took our client's money and transferred it when he had no authority to do so, and converted it for his own uses for whatever reason, which we don't know. It doesn't pass the basic test of the fact that he was given money. He agreed not to give it to anyone else. He gave the money to other third parties. It was our client's money. He had no authority to do so. And again, Alpina is his client, not plaintiff.
All right. I understand that there are some arguments that were made today that were not included in the original briefing. I am going to give you all 5 days from today to submit anything in writing that you want related to that and any responses. Okay.
Okay. I'm not familiar. So we didn't take this down. So the arguments were just made orally.
I will give Ms. Galloway 5 days to have her arguments in writing, and I will give you 5 days to respond. Okay.
Okay. Thank you, Your Honor.
Okay. Thank you, Your Honor.
And then if you all want to submit any proposed orders within 10 days of today.
Okay. Thank you so much.
Okay.
Submit them in Word format to Mr. Burnett. Okay.
Okay. Thank you.
All right. Thank you.
Okay.
You all are free to go.
Thank
Yes.
you, Your Honor.